Hey everybody, it's John at Fishing Hunter. It's Saturday, what's today, 6th? Yeah, April 6th, 2019. The Missouri Senate has passed a bill, Senate Bill 367, introduced by Senator Burleson, I guess it's pronounced. Read first time February 7th, 2019, and ordered printed. An act to repeal Section 1.320 RSMO, to enact in lieu thereof 9 new sections relating to additional protections to the right to bear arms. This is the state of Missouri. They've just, I guess it has to go to the governor to get signed, but there's a Republican-controlled House in Missouri, so I don't think there's going to be a whole lot of problem. Let me just, I want to scroll through this so you can see what it looks like. Sections 1.410 to 1.485 shall be known and may be cited as Second Amendment Preservation Act. General Assembly finds and declares that the General Assembly of the State of Missouri is firmly resolved to support and defend the United States Constitution against every aggression, whether foreign or domestic, and is duty-bound to observe every infraction of those principles which constitute the basis of the Union of the States, because only a faithful observance of those principles can secure the nation's existence and the public happiness. While acting through the United States Constitution, the people of several states created the federal government to be their agent in the exercise of a few defined powers, while reserving to the state governments the power to legislate on matters which concern the lives, liberties, and properties of citizens in the ordinary course of affairs. Limited by the federal government's powers affirmed under the 10th Amendment to the United States Constitution, which defines the total scope of federal power as being that which has been delegated by the people of the several states to the federal government, and all power not delegated to the federal government in the United States Constitution is reserved to the states respectively or to the people themselves. That's the 10th Amendment to the U.S. Constitution. Whether the federal government assumes powers that the people do not grant in the United States Constitution, its acts are unauthoritative, void, and of no force. The several states of the United States of America respect the proper role of the federal government, but reject the proposition that such respect requires unlimited submission. If the government created by a compact among the states was the exclusive or final judge of the extent of the powers granted to it by the states through the United States Constitution, the federal government's discretion, and not the United States Constitution, would necessarily become the measure of those powers. To the contrary, as in all other cases of compacts among powers having no common judge, each party has an equal right to judge for itself as to the infractions of the compact if infractions of the compact have occurred, as well as to determine the mode and measure of redress. I should learn to read better, right? Although the several states have granted supremacy to laws and treaties made under the powers granted in the United States Constitution, such supremacy does not extend to various federal statutes, executive orders, administrative orders, court orders, rules, regulations, or other actions which restrict or prohibit the manufacture, ownership, or use of firearms, firearm accessories, or ammunition exclusively within the borders of Missouri. Such statutes, executive orders, administrative orders, court orders, rules, regulations, and other actions exceed the powers granted to the federal government, except to the extent they are necessary and proper for governing and regulating land and naval forces of the United States, or for organizing, arming, and disciplining militia forces actively employed in the service of the United States Armed Forces. The people of the several states have given Congress the power to regulate commerce with foreign nations and among the several states, but regulating commerce does not include the power to limit citizens' right to keep and bear arms in defense of their families, neighbors, persons, or property, or to dictate as to what sort of arms and accessories law-abiding Missourians may buy, sell, exchange, or otherwise possess within the borders of this state. The people of the several states have also granted Congress the power to lay and collect taxes, duties, imports, and excises, to pay the debts and provide for the common defense and general welfare of the United States, and to make all laws which shall be necessary and proper for carrying into execution the powers vested by the United States Constitution in the government of the United States, or in any department or office thereof. These constitutional provisions merely identify the means by which the federal government may execute its limited powers, and shall not be so construed to grant unlimited power, because to do so would be to destroy the carefully constructed equilibrium between the federal and state governments. Consequently, the General Assembly rejects any claim that the taxing and spending powers of Congress can be used to diminish in any way the right of the people to keep and bear arms. The people of Missouri have vested the General Assembly with the authority to regulate the manufacture, possession, exchange, and use of firearms within the borders of this state, subject only to the limits imposed by the Second Amendment to the Constitution of the United States and the Missouri Constitution. And the General Assembly of the state of Missouri strongly promotes responsible gun ownership, including parental supervision of minors and the proper use, storage, and ownership of all firearms, the prompt reporting of stolen firearms, and the proper enforcement of all state gun laws. The General Assembly of the state of Missouri hereby condemns any unlawful transfer of firearms and the use of any firearm in any criminal or unlawful activity. The following federal acts, laws, executive orders, administrative orders, court orders, rules, and regulations shall be considered infringements on the people's right to keep and bear arms, as guaranteed by the Second Amendment of the Constitution of the United States and Article 1, Section 23 of the Constitution of Missouri, within the borders of this state, including but not limited to any tax, levy, fee, or stamp imposed on firearms, firearm accessories, or ammunition not common to all other goods and services which might reasonably be expected to create a chilling effect on the purchase or ownership of those items by law-abiding citizens. Any registered or tracking of firearms, firearm accessories, or ammunition which might reasonably be expected to create a chilling effect on the purchase or ownership of those items by law-abiding citizens. That's no gun registry. Any registering or tracking of the owners of firearms, firearm accessories, or ammunition which might reasonably be expected to create a chilling effect on the purchase or ownership of those items by law-abiding citizens. Any act forbidding the possession, ownership, or use or transfer of a firearm, firearm accessory, or ammunition by law-abiding citizens, and any act ordering the confiscation of firearms, firearm accessories, or ammunition from law-abiding citizens. This is great. Makes you want to pack up and move to Missouri, don't it? All federal acts, laws, executive orders, administrative orders, court orders, rules, regulations, regardless if enacted before or after the provisions of sections 1.410 or 1.485, which infringe on the people's right to keep and bear arms as guaranteed by the Second Amendment to the Constitution of the United States and Article 1, Section 23 of the Constitution of Missouri, shall be invalid in this state, shall not be recognized by this state, shall be specifically rejected by this state, and shall be considered null and void and of no effect in this state. 1.440, it shall be the duty of the courts and law enforcement agencies of this state to protect the rights of law-abiding citizens to keep and bear arms within the borders of this state and protect these rights from the infringements defined under Section 1.420. 1.450, no person, including any public officer or employee of this state or any political subdivision of this state, shall have the authority to enforce or attempt to enforce any federal acts, laws, executive orders, administrative orders, court orders, rules, regulations, statutes, or ordinance infringing on the right to keep and bear arms as described in Section 1.410. 1.460, any entity or person who acts knowingly as defined under Section 562.016 to violate the provisions of Section 1.450 or otherwise knowingly deprives a citizen of Missouri of the rights or privileges ensured by the Second Amendment of the Constitution of the United States or Article 1, Section 23 of the Constitution of Missouri while acting under color of any state or federal law shall be liable to the injured party in any action at law, suit in equity, or other proper proceedings for redress. In such actions, the court may award the prevailing party, other than the state of Missouri or any political subdivision of the state, reasonable attorney's fees and costs. Sovereign, official, or qualified immunity shall not be an affirmative defense in such actions. That means it doesn't matter who you work for, you can be charged. Sovereign immunity that's what cops have. That's why they can speed and pull out their badge and get away with not getting a speeding ticket. The 1.470, any person while acting as an official agent, employee, or deputy of the government of the United States, or while otherwise acting under the color of federal law within the borders of this state, who knowingly, as defined under Section 562.016, 1. Enforces or attempts to enforce any of the infringements identified in Section 1.410, or gives material aid and support to the efforts of others who enforce or attempt to enforce any of the infringements identified in Section 1.410, shall be permanently ineligible to serve as a law enforcement officer or supervise law enforcement officers for the state or any political subdivision of the state. Neither the state nor any political subdivision of the state shall employ as a law enforcement officer or supervisor of law enforcement officers any person who is ineligible to serve in such capacity under this section. Any person residing in or conducting business in a jurisdiction who believes that a law enforcement officer or a supervisor of law enforcement officers of such jurisdiction has taken action that would render that person ineligible under this section to serve in such capacity shall have standing to pursue an action for declaratory judgment in the circuit court of the county in which the action allegedly occurred, or in the circuit court of Cole County with respect to the employment eligibility of the law enforcement officer or the supervisor of law enforcement officers under this section. If a court determines that a law enforcement officer or supervisor of law enforcement officers has taken any action that would render him or her ineligible to serve in that capacity under this section, the law enforcement officer or supervisor of law enforcement officers shall immediately be terminated from his or her position, and the jurisdiction that had employed the ineligible law enforcement officer or supervisor of law enforcement officers shall be required to pay court costs and attorney fees associated with the declaratory judgment action that resulted in the finding of ineligibility. Nothing in this section shall preclude a person's right of appeal or remediation as provided under Section 5, Chapter 590. 1-480 or 1.480, sorry, for the purposes of sections 1.410 to 1.485, the term law-abiding citizen shall mean a person who is not otherwise precluded under state law from possessing a firearm, and shall not be construed to include anyone who is not legally present in the United States or the state of Missouri. 1.485, if any provision of sections 1.410 to 1.485 of the application thereof to any person or circumstances held invalid, such determination shall not affect the provisions or applications of sections 1.410 to 1.485, which may be given effect without the invalid provision or application, and the provisions of section 1.410 to 1.485 are severable. Excuse me. 1.320, the General Assembly of the State of Missouri strongly promotes responsible gun ownership, including parental supervision to minors and the proper use, storage, and ownership of all firearms the prompt reporting of stolen firearms, and the proper enforcement of all state gun laws. The General Assembly of the State of Missouri hereby condemns any unlawful transfer of firearms and the use of any firearm in any criminal or unlawful activity. So there you have it. Like I said, you probably want to pack your bags and move to Missouri right by now. This is unprecedented. This is the state of Missouri is taking firearms possession very seriously, taking the Second Amendment to the Constitution very seriously. Here in my home state of New Jersey, you don't have a Second Amendment right. Your ability to possess a firearm in New Jersey is a privilege granted by the state, and I'm thinking about moving. But anyway, I just wanted to pass this along. This is some great news for the gun owners of Missouri. Sadly enough, it doesn't happen. It's not happening everywhere in the country. But anyway, this is John, Fishing Hunter, fishinghunter.com, facebook.com/fishinghunter, DOTCOM. Have a great day.